So Dre, what is the purpose of the new Article 32s? Because back in the day when I was a baby prosecutor in the, 2000s, early 2000s, we used the Article 32 to discover the government's case and to grill the victims and to grill witnesses for the government. But that all changed within the last 5 years, where they've made it where victims don't have to go to Article 32s and government really doesn't even have to put any witnesses. So what is an Article 32?
Well, an Article 32 hearing is a preliminary hearing to understand if there's probable cause for the convening authority to send it to a court-martial or dispose of it in another way.
Is this any court-martial or just any specific court-martial?
Usually it's a general court-martial.
General court-martial, okay. And then what happens after you have this Article 32? He decides whether there's probable cause. What other decisions are made at an Article 32?
Well, I think from the convening authority or the prosecution perspective is whether or not they have a strong enough case to go forward, or if they need to dispose of it in another way. And that's where we can come in and put on a defense during the preliminary hearing to try to see where the blank spaces are in their case.
Right, so when this preliminary hearing officer calls the hearing to order, the government will usually put its case on these days just with the paper drill, put in the CID report, and he makes the determination whether that's sufficient probable cause. He also has to make the determination of whether or not there's jurisdiction over the accused and the offenses, and then he makes a recommendation to the convening authority as to what the proper disposition is, right? Whether it goes to a general courts-martial, special court-martial, or some alternate disposition. Are those decisions binding on the convening authority?
No, not from the investigation officer. Those decisions are not binding on the convening authority whatsoever. He can, and once again, that's where we can come in and try to convince the convening authority that this is not a case that needs to go to a court-martial, especially a general court-martial. This is why a civilian defense counsel can directly engage the convening authority and say, these are the reasons why you cannot take this case to a court-martial.
So like in a response to objections to the Article 32 or in a report to the investigative report, we would just address the convening authority as here are our issues, here's the issues that will be at trial.
Exactly.
And that will go to the convening authority, or will that just go to the SJA?
No, we could send it to the SJA, but from my practice experience, it's better just to go to the convening authority, include the SJA, but go to the convening authority directly. We have the ability to do that. We're not afraid to do it. So why not?
Right. So my experience has been since the changes to the Article 32 process, where they now require, at least in the Army, a JAG officer to be the 32 investigating officer. So no longer are these infantry or artillery guys sitting there making these decisions. They're trained lawyers. But what I've noticed from my defense perspective is I don't want to go in there and give the government what the defense case is and say, here's where our strengths are, here's where your weaknesses are. I use it typically to just listen to what the government's going to say. Because the government's going to give their opening. They say, defense, do you have an opening? I go, no. And then the government presents all of its evidence. They explain the evidence so that the investigating officer understands it. And then they ask, is there a closing argument? And the government often gives a closing argument with a nice PowerPoint presentation, which is a preview to what the case is that they're going to put on at trial. They ask me, defense, do you have a closing argument? And I go, no, because I don't want the government to know anything about my case at the Article 32 investigating level.
Yeah, and that's where Helixon's group experience, over 100 years combined experience comes in, where we can evaluate that decision, adjust fire if we need to, but understand that we're not going to give away our strategy when it might be a foregone conclusion that this is going to be a referred case.
Right, I recently represented a soldier who was facing sexual assault charges, and this really wasn't a sexual assault. It was a voluntary consensual affair that of course ended nastily, and so there was an allegation of sexual assault. That is one of the rare occasions when the defense came in and put on a very robust defense at an Article 32. with all the evidence of why this was a consensual relationship. And we convinced the investigating officer to find no probable cause for the sexual assault, no probable cause for some other offenses on the charge sheet. And ultimately, that case went from a court-martial to an Article 15. But that's one of the few exceptions where going in full blast as a defense counsel at a 32 was beneficial.
Right. Yeah. And like I said, you need somebody with the experience that you and I have to understand when is it appropriate to do that and when it's not. Where do we save our ML for? The court-martial, the preliminary hearing, but we know these issues just by trying hundreds of cases.
Right. And so it's essential that you get good legal advice as to how to handle the Article 32, whether to put on evidence or not put on evidence, and how to extract the most from the government so you can discover what their arguments are going to be.
Right. And so that's why it's important to bring us in early, not wait till after the case is referred, because our options become more limited. Of course, we can help after referral, but if you get us in early, we can give you the advice you need. We have the experience to get it done.
All right. So don't go alone in an Article 32 investigation. Make sure you get somebody to help you on your side. I'm Will Helixon, the Warrior Advocate. You defend the nation, we defend you.